What if a pregnancy is just days away from delivery, and the law still allows an abortion based on a doctor's professional judgment? That's the question now at the center of a fierce new battle in Massachusetts, after Governor Maura Healey signed a law removing the state's previous restrictions on abortions after 24 weeks. And one board-certified OB/GYN is warning that the change could create serious medical and ethical concerns. The law, signed August 10, changes the standard for abortions after 24 weeks. Under the previous Massachusetts law, abortions beyond that point were limited to specific circumstances involving the patient's life or health, or serious fetal conditions. The new law instead says an abortion may be performed by a physician based on the physician's professional judgment. It also prevents a medical review process from overriding the judgment of the treating physician and patient. Governor Healey says the change is about protecting patients facing heartbreaking pregnancy complications. She has described cases involving families who expected a healthy baby, only to receive devastating medical news late in pregnancy. Her argument is that those families shouldn't have to leave Massachusetts, travel hundreds of miles, and pay thousands of dollars to receive care from doctors they don't know. Supporters say the law puts difficult decisions where they believe they belong, between patients and their doctors. But opponents say there's another side to this story, and that's where Dr. Christina Francis, an OB/GYN and CEO of the American Association of Pro-Life Obstetricians and Gynecologists, has raised a major concern. Francis argues that when a pregnant patient faces a dangerous complication late in pregnancy, physicians can often deliver the baby rather than perform an abortion. She says an emergency C-section can sometimes be performed within minutes, while certain later pregnancy abortion procedures can take substantially longer. That argument is now becoming one of the central medical questions surrounding the new law. But it's important to separate medical emergencies from the broader legal debate. Not every complicated pregnancy is the same, and the safest treatment depends on the individual patient, the gestational age, the condition of the fetus, and the specific medical circumstances. The American College of Obstetricians and Gynecologists recognizes abortion as part of medical care, while also emphasizing that patients and clinicians should make decisions based on individual circumstances and evidence. There's also another claim from Francis that deserves careful fact-checking: the question of fetal pain. Francis argues that fetuses can experience pain as early as 12 weeks. However, that is not the consensus position of major medical organizations. ACOG says current scientific evidence indicates a fetus does not have the capacity to experience pain before at least 24 to 25 weeks. The Royal College of Obstetricians and Gynecologists has likewise reviewed the evidence and concluded that fetal pain perception cannot occur before 24 weeks, while noting that research into fetal awareness continues. And that disagreement matters because the new Massachusetts law is not simply about one medical procedure. It represents a major shift in how the state regulates abortions after 24 weeks. Massachusetts lawmakers voted 119 to 33 in the House before the measure ultimately moved through the Senate and reached Governor Healey's desk. The final law gives physicians significantly broader discretion than the previous statutory framework. Critics, including pro-life advocates such as Abby Johnson, argue that late-term abortion is being discussed too narrowly as something that happens only in extraordinary medical emergencies. They say the new law goes further than what many Americans, including some people who support abortion rights earlier in pregnancy, would consider acceptable. Supporters strongly disagree. They argue that lawmakers shouldn't create rigid rules for families facing catastrophic fetal diagnoses or dangerous pregnancy complications. In those situations, they say, forcing a patient to cross state lines can add delay, financial pressure, and emotional trauma at exactly the moment families are already struggling with devastating decisions. So what happens next? Massachusetts has now placed itself at the center of one of America's most intense abortion policy debates. Supporters see the law as protection for patients and doctors. Opponents see it as the removal of important safeguards. And physicians themselves remain divided over how medicine, patient autonomy, fetal development, and state law should intersect. The bigger question may not be whether this debate ends in Massachusetts. It's whether other states will follow the same path, or move in the opposite direction. With abortion laws becoming increasingly different from state to state, Massachusetts could become a model for one side of the national debate, while states with tighter restrictions become the model for the other. And that means this fight is likely far from over. If you found this update helpful, don't forget to like the video, subscribe to Unix Media, and turn on notifications so you never miss the latest news. Thanks for watching.